Hi, this is Fred Neiman of Hanlon Neiman, a law firm located in central New Jersey practicing estate planning and estate administration in all 21 counties of the state of New Jersey. I'm going to talk to you about a fairly complicated topic this morning. I'm going to keep it brief because it is complicated. It's in the subject matter called disclaimers. Now, disclaimers are used oftentimes to save estate and death taxes. In New Jersey, you may not be aware that if you own property or assets in excess of $675,000, you're subject to death tax. The federal government has seen fit to, by and large, eliminate the death tax for most individuals in the country, but not New Jersey, which is why I tell all my clients that have any kind of savings and have worked hard all your life, best thing you can do is get out of this state. Move to another state where death taxes are not so punitive. But maybe that's not something that you can do. But you don't want to pay this state any more than you absolutely have to. Well, there is a solution if you're married. It's called disclaimer planning. And if you're single, there's also another way to save taxes through the use of disclaimers. Disclaimer is an instrument, a document filed with the county clerk and the circuit, which says in essence, I'm entitled to receive property, but I decline it. Why would you decline something of value? Well, one, maybe you don't need the money. Two, maybe if you receive it, you're going to be subject to claims of creditors or others in the future. Disclaimer planning is very effective as a way of making sure that in the future, you can maximize all of your available deductions and exemptions under New Jersey law, which otherwise would be lost if you receive an inheritance or a gift of value. Let's use an example. You're a husband and wife. You have an estate of about $1,250,000. If you leave everything to your surviving spouse, that's fine. There'll be no New Jersey death tax. But when your surviving spouse dies, his or her estate will only get one exemption for $675,000, and everything over that will now be subject to New Jersey death tax. How do you avoid that? You avoid it through the use of disclaimers. Under appropriate circumstances, the surviving spouse can file the disclaimer, refuse to take a certain portion of the inheritance, and if the will of the family is set up correctly, we can actually create a trust under the estate of the first spouse to die, which gives them the full benefit of their exemption and allows them the use of the funds for the remainder of their spouse's life without any adverse death tax upon the second to die's estate. I know it sounded complicated, but I want you to just remember this word, disclaimer. Now I want you to think of two words, disclaimer planning. When you go see your estate planning attorney, tell them you watched this video and you heard there's ways to save on death taxes through the use of disclaimers. Let him or her explain to you the concept more. Remember also, if there's creditors involved, disclaimers can be used, and I'm going to explain to you about that in my next video.